Howdy, and welcome to the show. Cooper's Code focuses on legal issues and notable practitioners, distilling wisdom so we all achieve the best results for our clients. I'm Miles Cooper, and I'm very excited to sit down with Nathaniel Leeds. Nathaniel is a medical malpractice lawyer with Mitchell Leeds LLP, taking on challenging cases on behalf of those harmed by healthcare errors. On an intellectual level, Nathaniel is one of the smartest people I know. His interests are broad, encompassing medicine, history, and mechanics, and whatever else currently attracts his or his son's attention. As a result, one of his talents is following whatever fascinates him down the rabbit hole to digest everything there is to know about an issue and become a subject matter expert. With his passion for learning, there is no doubt why he excels in the tremendously challenging, high-stakes, and highly academic medical malpractice realm. Nathaniel grew up in Boulder, Colorado, with a physician mother and university professor father. The medical exposure in the home, coupled with a cancer battle in his early 20s, provided him with unique viewpoints into medicine. Add in math experience at the University of Chicago, a quant factory, and you get someone unafraid to dig into statistical analysis contained within peer-reviewed literature. A stint with the Merced County District Attorney's office bolstered his trial chops. A note as you listen, please know that Nathaniel is a longtime friend and cycling partner with whom I've spitballed countless cases, negotiating tactics and strategy. If I appear overly familiar or overly researched, that's where it comes from. One other note for anyone watching this on our YouTube channel, my nails. I know we'll get a question in the comments, so I'm heading it off here. My daughter offered to paint my nails earlier this week. How much longer will she want to devote an hour of her evening to her dad? Who knows? And I'll take whatever time is offered. Memento mori, right? And with that, I hope you enjoy this wide-ranging conversation with Nathaniel Leeds. If you're enjoying what we're doing here with Cooper's Code, please help us extend our reach by giving us a 5-star review on Apple Podcasts and consider sharing an episode with a friend. Welcome to the show, Nathaniel.
Well, thank you for having me, Miles.
Why don't we just kind of go straight into a significant difference in the personal injury litigation realm. And I'm going to start here, and I suspect we're going to follow it in many different directions. How do you see medical malpractice litigation being different from your standard run-of-the-mill personal injury case?
I would say that there's kind of two things that we need to think about in medical malpractice. One is that our loss rate is significantly higher than what you have in personal injury cases. You know, in personal injury case, often you have a pretty good sense that there's liability and causation at the beginning of the case. And you often don't have a lot of actors involved. In medical cases, you know, as attorneys who practice in this area, we're not physicians, right? So there's going to be a lot of times when we have a kind of gut sense about something that turns out, once we've reviewed and really dug in, doesn't turn out to be the way it was. And also we're practicing in environments where you can have a lot of overlapping responsibility. I had an early case where, you know, it was what I'd call a bookend case, which is somebody came in with a curable condition and ended up dead. Well, we were pretty sure things had broken down. Between those 2 points, there were 19 different professionals who had interacted with that person. What that meant was 19 different defendants before we weeded it down. So I'd say that that complexity is hard. The other thing that's hard is that our cases are capped, which means we're often in cases where there's very significant damages that we can't recover for.
When you talk about that, whether you're in California listening to this or outside of California, I think most people are familiar with caps in medical malpractice cases. And MICRA, I believe, was the law, and I think it was 1975, but I could be wrong. I also know that the law was changed recently and those caps were raised. And there are a number of lawyers who used to turn down medical malpractice cases who are all of a sudden starting to nose around that field yet again. I'm giving you that as a springboard to talk a little bit about those caps and the appearance of what I might call dabblers in the medical malpractice realm.
I don't want to disparage anybody who dabbles because I'd encourage anybody who's interested in this area to dabble. You know, everybody starts off as a dabbler until they're an expert. And frankly, one of the things that attracts me to the field is that I continue to be a dabbler. There's areas of medicine that I don't know very well. There's a lot of areas of medicine I don't know very well. You know, and generally, one of the things I find most rewarding about the cases is that a large part of my docket involves medical conditions, medical issues that I'm completely unfamiliar with. So, even those of us who are professionals, we're just good at being dabblers. So I'd encourage those people to get into it, because I think that, almost everybody will interact with medicine at one point or another in their lives. They're interacting with professionals who are making very high stakes decisions. Most of the decisions are very good. Sometimes those decisions are not good. You get a lot of bad outcomes. And when you have a bad outcome, everybody deserves an independent attorney to look over what happened. We in our office are generally proceeding forward with about 1 out of every 1,000 cases that comes through our website or is just a retail contact. We're providing a service for those 999 people who we can't help. And the service that we're providing is we're looking in and we're saying, this doesn't look like a case, and giving the people the confidence to move on with their lives and say, I lost a loved one, I suffered a horrible injury, but it wasn't because somebody did something wrong. So, dabble away.
Can I ask you a question about that piece? When somebody calls and says, this happened, I think it's malpractice, I know that many lawyers are reluctant to say anything other than, I've made a business decision not to take your case. Do you do more than that in terms of providing information to people so that their questions get answered?
Well, I'll say that early in my career, when we didn't have as much flow, I did more of that. I think it's a valuable part of the service that we provide.
To actually give them an answer?
Yes.
Okay.
Yeah. It'll always be hedged with, I'm a lawyer, not a doctor, but I think it's valuable to give people the answer, because that's often what people are calling for. I think of, kind of on the extreme end of our cases, we have cases with, fetal deaths, right? There's no amount of money that it can compensate you for losing a child. You're not suffering any economic harm, but you're suffering a huge emotional harm from that. It's a very tragic thing for a person to go through. That person needs somebody who is not a doctor to say to them, yeah, we've looked at it, and, as hard as this is for you, we don't think that litigation is right for you. Otherwise, they won't be able to process what's happened for them and move on. They'll continue to have anger over the whole system. And so, I think that rejecting cases is, not an unfortunate part of our job, but actually a big part of our job, where we're adding a lot of value for our clients and our communities. And so, when I first started out and attorneys would refer cases to me, one of the things that I did was I would always write back a letter that did my best job of explaining why I wasn't taking the case. Because these are serious cases. It's not, and they absolutely deserve more attention than just, this is a business decision, we don't want to do it. And the other reason to have a dialogue is, even with very unsophisticated clients, they can't understand the medicine. And sometimes they say things to me that I didn't think about or didn't anticipate. If I don't engage in that dialogue, I might pass up on the ability to help somebody out who really deserves help and needs help. And so we do as much of it as we can. At this point, unfortunately, we're getting enough inquiries that it's not possible for me to be on the phone all day long explaining cases. But, for instance, today I had a very substantial conversation with an individual who lost his kidneys because of what looked initially like malpractice. And in fact, some clinicians had told him they were concerned about the care he received. Initially, I thought it was a case. And then, we did our work and our due diligence, and we no longer believe it's the case. It was important for me to have that conversation with him, because, the conversation, or the experience for him is not going to end here. He's going to be on dialysis for years and years ahead. He deserves to have somebody who's in his corner saying, I looked at it, you just had a really bad outcome, and there's nothing that anybody did wrong to you.
I would love to use that as an opportunity to learn a little bit more about your methodology. When you are getting an inquiry like that, what steps do you take to either learn the medicine if it is not an area that you are regularly in, or gather more information to help make sure that you are providing the correct direction, either in saying, I don't see something here, or in taking the case on and prosecuting it?
Well, I'd say it's really a range of things depending on what we're looking at. We have and are continuing to build out our intake team. And We have a physician assistant on our intake team. Some of the other people on our intake team have been doing medical malpractice for 20 years. So we're having a lot of filtering that's happening before anything's coming to me. Okay, and they'll have a sense of, are we in the ballpark of something that doesn't look right? All our cases start off with a smell. When you're talking about an automotive accident, it's kind of like, well, I woke up this morning, I was going off to work, and now I'm badly injured. Generally, that means either you did something wrong or somebody else did something wrong. You take the same in a medical context. I woke up this morning, I was sick, I went to a doctor, I went to a hospital, I'm now even sicker. That doesn't mean anything happened, right? That sometimes is just, unfortunately, we all get sick, and illnesses can be very dangerous. So, our intake team kind of does this smell wrong test. Once that's done, it'll come to me. And sometimes it's a pathology I know. There's a couple that we see regularly. I'll give the example of cauda equina. It's an injury to the lower regions of the spine. It's the kind of equivalent of a rear ender for medical malpractice practitioners. Anybody who's done this work has probably seen 20 or 30 cauda equina cases in their careers.
And where do they pop up? Is it like a orthopedic surgery case that then turns into that, or is it something else?
It's generally that you'll have a herniation, you'll have an acute herniation and sudden onset back pain, and people will go in, and if it's not decompressed promptly, then they'll start having neurological problems. And because that kind of, I just strained my back, is something that doctors see all the time, it's very difficult for doctors to decide which are I've just strained my backs, I need to really worry about this one from the generic ones that they see that can be managed in an outpatient setting. And, that's just a fraught question for them, and errors happen there. But, if we have something like that, I'm very familiar with it. Reading field heart monitoring strips. Once you've learned to read field heart monitoring strips, you can read them. We're not going to need to go to professionals. Other times, we've had cases that come in that are extremely exotic. I was looking at a heart transplant rejection case at one point. You've got to be really brave to think you understand heart transplants and rejection without a pretty significant bunch of experts to educate you. So in that case, I think we spent $30,000, $40,000 on expert reviews before we decided it wasn't a case. So it can be all sorts of levels. And then the other thing that's really different about our practice area is, we really try to cultivate good relationships with opposing counsel. And one of the reasons for that is they will raise issues with us that, however good we are, we might not have anticipated. So, and, I regret to say it, but, sometimes they're right. And when they're right, we'll be deep into litigation and realize that, we've just been wrong, or our expert's been wrong, and have to abandon the case. So that, inquiry process, can be anything from, my staff doesn't think it sounds like there's a problem, to we're halfway through litigation and we have to change course.
When you talk about opposing counsel and having a relationship with them, my understanding is the medical malpractice bar is a somewhat small bar. Is that fair?
Yeah, I would say much smaller than most practice areas, yeah.
Does that help in terms of establishing relationships, or are there other tools that you use to establish relationships when you're encountering somebody who you haven't worked with before?
Well, I will say that, having a small bar helps. So you can always find somebody who you're friendly with who knows this person. The other thing that helps is that we're dealing with a lot of multi-defendant cases where one defendant's best defense is to point the fingers at another defendant. And so, if we were just kind of guns blazing against everybody and we're not receptive to those conversations, you easily get caught in a situation where you're trying to herd cats and you don't, the real target is hiding among a bunch of other people.
I would love, if you can, in just say a generic case where there are 4 or 5 defendants and you're not quite sure where the cat is yet. How do you start engaging opposing counsel to, I'll use it here, kitty, to get that, the target defendant the defendant that stands proud to get them to show up?
Okay, so the target defendant is going to hide in the weeds until everybody else is gone. So it's really a matter of trying to call people out, call the ones who are not problems out. So, there's a number of different strategies. I really like a high touch strategy where I'm just calling and yapping with opposing counsel every chance I get. It's harder in post-COVID, but before COVID, we'd have these depositions and, you just talk to everybody in the hallway. I once was in a deposition where every time I went into the bathroom, one of the opposing attorneys would come into the bathroom and tell me something that I was interested in. I kept going to the bathroom a lot because the attorneys, they didn't want to be seen attacking the real target because they don't like being seen going against their own, but they were really happy for me to do it. And they were absolutely going to feed me everything they could so that I could effectively go after the target. And when you say having a conversation with you in the bathroom, you didn't follow up on X, but you might ask about why? Absolutely. Or texts during depots. You'll get some of that stuff. At this point, it's very rare that I'm in a case where I don't know the attorneys or at least know people at their firms. So that type of, hey, I've got to talk to you in the bathroom doesn't happen as much to me anymore. It's now more likely going to be, a phone call. But, before a big deposition, I'll just start calling people up. I'll say, I'm taking a deposition. What, anything you want to talk about? And if one of the other defendant's attorneys thinks there's some advantage to sharing information with me, they will. The other thing that we do is we invite a lot of motions for summary judgment. Elaborate on that, please. Well, so, we will have situations in which I'm trying to narrow in on a particular defendant. I'm not just going to dismiss the defendants I'm not interested in. I don't want the empty chair. I'm going to invite a motion for summary judgment and let it be granted. And that way I don't have a problem with somebody saying, oh, well, that person was actually at fault. And just because I think there are different levels of experience who are listening to us, when a summary judgment motion gets granted, does that mean that that's an adjudication that the person who brought it was not negligent? So they can't appear as a percentage on the verdict form? They cannot. Okay. It is worth saying that, sometimes the best defense in medical malpractice cases, that guy did it. Well, if you can't actually say that, then it becomes a less viable defense for you. So when I'm inviting a motion for summary judgment from a secondary player, I'm also cutting off the primary player's defense. So what we'll do is, I'll call up and if I have a target, I'll call up the target's counsel and I'll say, hey, I'm inviting everybody else to file motions for summary judgment. What do you want to do? And the target may say to me, well, there's this problem with that person and, we're going to, in extreme cases, the target will then come out and oppose the motion for summary judgment. Sometimes they'll say to me, I'm really not the target. It should be that guy. We've actually had situations where I will invite motions for summary judgment from pretty much everybody, knowing that it'll sort things out. And then while the motion is pending, I'll make a decision about which ones I'm going to oppose and which ones I'm not going to oppose. People start getting very talkative when they think that I'm not going to oppose a motion for summary judgment and leave their person in the case when they say to themselves, well, if I can convince Nathaniel not to oppose mine and oppose his, then I'm going to get my client out of the case. As we talk through this, and I'm sensing that there's high stakes, high leverage, lots of opportunities to apply pressure, both from the medical side, but also from the strategy side of, I don't want to say playing people against each other, but using different people's interests to influence outcome and drive you to what hopefully is a negotiated outcome for your client. I'd say that's fair. We have all sorts of different cases. Sometimes there's only one actor. A surgery case. We just settled a surgery case for a little bit more than $3 million. There was one surgeon. He had the tools in his hand. We weren't going to play a lot of these games. But sometimes we're in a hospital context where there's a lot of different people with a lot of different agendas. And I'd say, the most interesting of those kind of come together like mob cases. You're doing a roll-up. you're putting pressure on lower level actors, nurses, or medical students, or hospitalists to push at the person who you're really targeting.
At the risk of tangenting into an area, you worked as a district attorney in Merced. Did any of that background, when you talk about mob roll-up, any of that background inform your strategy approach, or was the district attorney background more of general trial experience?
I would say there were two things. I'd say general trial experience, although I would say that the skills you get doing criminal trials are not as transferable to civil as I believed at the time.
I'm going to ask you a question on that because I know for a lot of people that is a route that they choose to go since it is so hard to get civil trials these days as a younger lawyer typically. So people will do a district attorney or a public defender round to build up their skills. I'd love to hear when you say it's not as transferable, to what extent?
Well, when you are a criminal prosecutor, you start on third base. And you get very familiar with starting on third base. And you don't realize all the stuff you need to do to build up credibility with a jury. I mean, that's a large part of your trial skills is, especially when you're younger lawyer, right? And you're younger than everybody else in the room. You're younger than your jury, right? Establishing yourself as somebody that can take seriously is a large part of what you need to do with a judge and with the court. Well, when you're a criminal prosecutor, that's already done for you.
Would you say that if somebody was solely going into the criminal realm to develop skills that a public defender would be a better position to take?
I don't know, having not been a public defender. They have challenges as well, okay? I think both being a prosecutor and criminal defense attorney, you're going to get the basic skills of how to be comfortable in front of a jury, how to be comfortable in a courtroom, just getting the fear part out. You're also going to get the basic skills of really knowing your stuff. I mean, how detailed do you have to be in knowing this police report? How detailed do you have to be in knowing these things? Getting that level of precision is not something that, some people may be born with it. I certainly wasn't. And until you've, stuck your foot deeply into wherever you want to say you stuck it in front of a jury a couple times, you don't have that fear to really get to that level of precision that I think you need to have to do real significant trial work. So you're going to get skills, but I'd say, if there's 10 skills you need to get to be an effective trial lawyer, I'd say the criminal realm will get you 4 of them. That's pretty good. It's better than, working at Wendy's, which will get you 1 of them.
Would that be customer service?
Yeah.
Okay.
And confidence. Ability to handle conflict. But
hot topics.
Well done. Yeah.
No, that was not funny.
Yeah. So, you get some, but I'd say there's a lot that you need to get beyond those skills. As far as what I got from criminal law, part of it was that. Part of it was just the confidence of being in a courtroom. But the other thing I think that was really valuable that I don't think that most civil practice trains you on is actually negotiation skills. In criminal courtroom, you know the defense attorneys, you negotiate face-to-face with the defense attorneys, and they may not have good client control. That is something that's challenging for them, it's challenging for you. Learning how to work through those things is an important part of being an attorney. I think that in civil, especially since we have so much ADR, a lot of people have just failed to learn how to negotiate.
I know how to negotiate. I call the mediator, and the mediator does all the work.
Exactly. I think that is, unfortunately, the approach a lot of people take. And so you see this really aggressive bellicose behavior or inability to establish rapport. I think, working a criminal calendar for a year and spending time in the hallway negotiating teaches you, how to negotiate, how to figure out when you need to change position. If you've been really strident and you realize your case is going, falling apart, how do you do that in a way that doesn't, implicate your own ego in some way so that you can actually get it done? I think those are valuable skills as well that you get from criminal. As far as, we were talking about this idea of rolling up witnesses.
Right.
I would say that the criminal work that I did not often have those elements. It occasionally would. But, I'd say that more of learning those skills comes from general following cases that are happening and Netflix is a great teacher in those areas. And then, when you get into medical malpractice cases, my saying used to be that I didn't sue for money, I sued for information. I'm bringing people into cases because it's going to be much easier for me to find out how things really work from a defendant who has every incentive to educate me than it is for me to paid expert who may have weird incentives or weird views of medicine. If the doctor at this facility says this is the way we do it at the facility, that is going to establish the standard of care a lot more than me paying an expert. And so, you start with suing a lot of people and then using them as ways of getting information. And then, pretty early on, you realize if you take the deposition of the kingpin first, then you're walking into the deposition, you're completely ignorant of everything else. And so it doesn't take long, one or two cases that happens to you and the light bulb will go on and you'll say, it really works better when I take the deposition of people who I can actually scare, who might actually tell me something, than if I go straight at the king right off.
You mentioned Netflix as a way to pick up some skills. What do you mean by that?
Well, everybody loves true crime, right? There's a lot of shows about building cases. And, the one thing that I think is common between criminal prosecution and medical malpractice, apart from this kind of roll-up thing, is cops are rarely criminals, right? Everything that they are criticizing or everything you're prosecuting is behind a veil and is happening in a world that you will never understand. I often felt when I was looking at criminal cases that I was kind of looking through a peephole. The only information I had was the 911 call and what the police saw when they showed up. And there was an entire world of relationships behind those things that was difficult to access. It's very similar in a medical malpractice case, right? I am not a physician. I've never worked in a hospital. I've never been in a surgical suite, right? It all is happening kind of at this remove from me. My job is to, from the outside, look in. So you see a lot of those tensions in any good plot development. In The Wire, you see how are they the big challenge is there's this organization, and The Wire is the Barksdale gang or whatever it was. And it's a question of, okay, there's some people in those organizations which are going to be aligned with you. There may be a nurse's attorney who is suddenly aligned with me and wants to feed me information. Okay, how useful is that person? Is their information self-serving? I still, I can't get into the, behind that veil without them. But, I've got somebody who's kind of bringing me in who is as credible as a criminal confidential informant. I may have to turn on this person. It's the same sort of dynamics. And you see those, there's no show on medical malpractice, but, you watch some true crime shows and you'll see many of the dynamics that we see because it's the same thing. It's, you have a complicated world of rich relationships among very sophisticated players that is completely opaque to you when you first step in the case. It's not like a PI case, right? PI case, if you're talking automobile case, we all drive. We know what that world looks like. I don't need somebody to shepherd me into how do I drive a car. Medical malpractice, I always need somebody to shepherd me in. And it's either going to be somebody I hire as an expert. It may be, I have a lot of relationships with people who I just curbside with. If it's not, it's going to be defense counsel or a minor defendant who helps me start to understand things.
Thank you for listening, and tune in next week for part 2 of this 3-part series. Please email us at podcast@coopers.law with questions, comments, feedback, and suggestions on ways in which you have approached medical malpractice cases. Like what you heard? Share us with a colleague and leave us a 5-star review on your podcast platform of choice. To all of you doing justice out there, happy hunting.